Well, you know, when you get to bring back some of your favorite guests, it just makes me smile on a cloudy day. We're talking about John Hugg, who's back with us, attorney at law with Hugg & Associates, who specializes in estate planning, business succession planning, and elder law, who's also a frequent speaker on these issues and host of seminars throughout the Seattle area. Welcome back, John. How are you?
I'm doing okay. Thanks, Ben.
Good. Did you have a good weekend?
Yeah, it was okay. Pretty relaxing for the most part.
Yeah.
You?
Yeah, it wasn't very relaxing. We went to this big event on Saturday night. Friday night, my buddies and I got to go have dinner and drinks.
There you go.
Yeah, and then I got to get up with the kids Saturday morning. I tell you, that's the hardest part if you go out with your friends sometimes.
So you're out late? And then
you're out late with some of my high school buddies. We went out, and then, my wife, love her, she's fantastic. But if I go out with my buddies, guess what? That means I get baby in the morning. It's kind of the payment. So anyways, it was fun. And then, of course, we got to go to the Michael Ryan Patterson Foundation's event on Saturday night, which was really fun also.
Great.
Yeah, pictures and whatnot, I'm sure, online. Well, John, let's talk a little bit about what I tend to think is kind of this people put it off, and they put it off, and they put it off, which is in your business. I mean, you're trying to convince people to think about things they probably don't want to think about.
Right. Yeah, thinking about planning for death.
Yeah.
What happens after that? So, yes, that's what I'm planning, and talking to people about and trying to get them to sort of get moving and not put it off anymore, because at some point you can't put it off. At some point it will come back.
It's kind of like the IRS. Eventually it'll catch up with you.
Yeah, eventually it'll catch up with you. Maybe, it won't be as painful as the IRS, but
hopefully hopefully not. So John, let's talk a little bit about, one of the big things you've always talked about avoiding, which is probate. But probate may be kind of a technical jargon word that a lot of people don't understand what it means.
Right.
Why don't we do, what is probate exactly?
Probate is the process that you'll go through after you die. So you won't actually go through it, but your spouse,
you're getting religious on us,
your kids, they will go through it. And generally what you do in probate is you administer your estate. When you pass away, an estate is sort of automatically created of all of your stuff. So all of your assets, your house, car, bank account, stocks, bonds, everything, that becomes and creates your estate. And then we need a way to administer it, as in pay your bills and then transfer the ownership to your wife, to your kids, depending on the circumstances. And that is the entire process of probate, in a nutshell.
And so you go through this, it's kind of the process of other people determining what's going to happen with all your stuff.
Well, actually,
it's no longer yours.
Yeah, well, hopefully you've determined exactly what's going to happen with all of your stuff beforehand. So that's sort of what I've been preaching, for lack of a better word, each time I come on here, is plan in advance. So
probate isn't just if you don't have all your ducks in a row. It goes on no matter what.
It can, yes. So even if you don't have a will, you can still go through probate, and the law will basically take care of everything for you. Again, whether you like it or not, whether it's what you want or not. Washington has its own laws of intestacy. So if you don't have a will, it'll tell you exactly who's going to get what and in what amounts. And which is, again, why I basically say that you should be planning this stuff in advance and doing your wills and the other related documents, so that when that time comes, you've got it all planned out and everybody can easily follow it and make it as simple and painless as possible.
But then there's ways to actually avoid it. Is that right? And that's what you recommend, is trying to avoid the process.
Well, there are ways to avoid it. I don't necessarily recommend avoiding it. That is basically going to be dependent on each and every situation. Some people should probably try to avoid it. Other people, it works just fine. And in Washington, probate is not the worst thing in the world. The probate process here is relatively streamlined by comparison to someplace else, like California, where it is not so streamlined. And so it's not nearly as bad as many people think. However, there are plenty of situations where you do want to avoid probate. With a lot of my clients, they come to me, they've heard, usually from somebody else, this estate, my uncle set up a living trust, and it was the smoothest, easiest process ever. So my uncle, he did it right. So I want to do what he did. More likely, you'll get the thing like, well, my sister's husband's family spent 6 years in court fighting over this and that and whatnot. I want to stay away from court. What do I do so I don't ever have to go into court? And there are different ways to do that. And one of the primary ways to do that is with a revocable living trust.
And so this is something that you set up hopefully while you're alive. Well,
you can only set it up while you're alive.
Yeah, that would be true, huh? You can't really set it up once you're gone.
Well, yeah, you set it up while you're alive, and basically the way it works, I mean, there's two different types of trusts. You can put a trust into two different camps. One is what's called a testamentary trust, a trust that is included within your will, and it only becomes effective after you've died and your will is admitted to probate. The other type of trust is a living trust, one that you create while you are alive. So let's see. Let's take you for example.
Sure.
Let's say you and your wife want to set up a living trust. You want to avoid probate. So what we would do is you and your wife create the trust. You and your wife are the trustees of the trust. So you still have complete control over all of your assets, which is, for a lot of people, very important. A lot of people don't want to give up control of their assets. Now, in some cases, that's something you want to do and need to do, but a lot of people don't want to do that, especially if you're younger. You don't want to give up control of your assets.
No, my kid is not old enough to figure out what to do with them.
Well, someday he will be old enough,
and I will be old enough where I will not know what to do with them. But
exactly.
So you end up with essentially a living trust.
Exactly. And
a trust is actually like, it's almost like your own little company of money. I mean, right? It's almost like setting up a little personal corporation with all your stuff.
That is a good way to think about it. And I do actually explain that to clients in that way. It's sort of like setting up your own little company. You control it, and you're the beneficiary, and you take care of it for your own benefit. And that's one of the pluses of this type of a trust. The other big plus of this type of trust is you can change it at any time because it's revocable. You could revoke it, terminate it. You could make changes to it. You can cut that kid out if you don't want them to inherit anything, and you can make these changes at any point in time up until you die or basically become
until then.
Yeah, exactly.
And
only until then.
And so how does it really work? I mean, you're setting up, tell us how it really works. Okay. So you put money into it, right?
Right. What you do is, after we set up the trust, you create an actual document, you've signed everything, and then we need to transfer your assets to that trust. And the way we do that, say with real estate, is we create a deed. You basically signed a warranty deed a warranty deed was signed to you when you took title in your house. Now you're going to sign a deed from yourself to the trust. So the trust will become the technical owner of your real estate. Now you're still a trustee, so you control it, and you're the beneficiary, so you can live in the house and continue to enjoy it. And the same thing with all of your other assets. So you've got your bank account. Again, you do the same thing. You go to the bank, you retitle it into the name of the trust, and then as trustee, you administer it. As beneficiary, you are able to use it.
So why would you use this?
Well, there's a couple of different...
Because I have a bank account with my name on it.
Right. Well, there's a couple of different reasons why you would use it. First and foremost, what we've been talking about, avoiding probate. If avoiding probate is important to you, it is a very good vehicle to do that, if you have done it right. And by doing it right, that basically means you have transferred into the trust all of the important assets and essentially your entire estate into that trust. One of the problems, one of the pitfalls of a living trust is a lot of people will set them up and then they won't actually follow through and transfer anything to them. So they're not getting any of the benefit. They're still going to have to go through probate because they never put their assets into the trust.
So in some ways, is this like, well, the trust never dies? I mean, the trust lives on without you.
Well, the trust can live on without you, but it can only live on for a certain period of time. And in Washington, That's going to be 150 years, in this case, after you die. So after you die, 150
So when
years
literally
after.
we are all flying around with old jetpacks and, taking trips for vacation to the moon, it may expire.
It may, sooner or later.
And that's like in probably 50 years. At 100, I can't even tell you what's going to happen in 150. We'll be zapping each other in places.
But in the meantime, a lot of trusts don't ever live on that long. They will terminate at some point so in this situation, you're setting everything up, putting everything in trust for you and your wife. After you're both gone, those assets will remain in trust for your children. And you may say, okay, at age 30, my children can get all these assets outright, and then the trust would terminate at that point. So again, you can set everything up the same way you would just with your will. You only use it with, you basically do it sort of in advance. And there is probably the most important time where I would use a living trust is if you are fortunate enough to have property in multiple states. So if you have real estate here and you have real estate in another state, say California, you're definitely going to want to set up, all things being equal, set up a living trust and at least transfer that out-of-state property to that trust. And that way, you will avoid the probate in the other state. You may still have a probate here in Washington, but you won't have two probates going on at the same time, which is obviously you've got two lawyers and you're just running the meter, at twice.
Slowly all the money just runs out, right?
Exactly.
And
yeah.
nothing
it
less,
winds up with the
nothing
lawyers.
left but the lawyers fighting over the scraps.
Yeah.
We're here with John Hugg, attorney at law with Hugg and Associates. Just so I should be telling about fighting over the scraps, right? As I'm talking to you,
Absolutely. If
bringing
you
up
want to
the
fight
knives.
over the scraps, I'll help with that too.
I bet you will. Well, John, we do have to go to break in just a quick minute, but let's just hit again on failing to fund the trust, because this seems like one of those steps that a lot of people would take, such as a financial plan or thinking they're going to pay off their mortgage faster. That sounds really, really good on the front end, but then takes a little bit of time and a little bit of work and dedication and discipline to actually make it happen, make it work. Mm-hmm. Do you see that as one of the biggest problems? Is it's conceptually good, but life gets in the way sometimes?
It shouldn't be, and the reason it shouldn't be, although again, the client, of course, has to take responsibility for their own situation, their own actions, but the attorney should be driving everything. So the attorney should be creating the initial documents and telling the client what to do. That being said, I can't go to the bank for them and change over the title on their account. Only they can do that. So I can tell them exactly what to do and exactly how to title it, and then follow up. But they have to actually do it.
And is this just, would you do this with your regular checking and savings account, or are these like your bigger accounts that maybe, you have your whatever investments in, or, is it both?
It depends on the situation. Certainly it would be for the bigger accounts, but you could certainly have a smaller, simple
the account my wife doesn't know about. Does that one have to go in there?
We might want to talk about that off the air.
Oh, John, she's got one I don't know about too, so it's okay. I don't know the word, but it's like mutual destruction, right?
Yeah, there you go.
John, thanks so much for joining us again. John Hugg with Hugg and Associates. When we come back, Heather Moore is going to join us. She's going to ask us some questions. We're going to do our best to answer them. We'll be right back after this break. You're listening to Brashenomics.